2007. So even after the pilot project rules, the first set of rules that validated the pilot project, again, were limited to the commercial court. And those were then followed by the Judicature mediation rules of 2013, which have now been replaced by the Judicature Court-Annexed mediation rules of 2026, which is what we're going to be discussing here. So you can see from the 2023 rules for the pilot project to the Court-Annexed mediation rules of 2026, we're looking at 23 years of proof of concept on mediation in the Ugandan judiciary, which is quite a long time. And you can also see that this is the fourth set of rules on mediation that have been promulgated. I think one of the reasons why the rules started at the commercial court was that at the time when some of us joined the court at the time, and those that we found there, we thought that we could not simply manage the workload by hearing each and every case that came to trial. The other thing that we noticed is that even during trial, we saw people coming to us and saying, look, we want to terminate this trial here because we have settled the commercial dispute. And so it became apparent that even though we went to trial, some of the commercial disputes were being settled. And we thought that it is important to have a structured process to do this. And we know that most of the disputes that came to the commercial court arose out of a contract. And, you know, in a contract, you have two people who voluntarily come into a contract to pursue either a business or other commercial purpose. And so really the people who are involved in a commercial dispute, ordinarily are people who know each other. The people who are in business with each other. There are people who have a target mostly to make a profit, to make money. And we all know that time is money. And loss of time means loss of money. And therefore, we decided then under the project called Commercial Justice Reform Program to try alternative dispute resolution with a focus on mediation. The first response was a little bit cold, largely from the bar, because people had not initially understood what mediation is. It had not been part of the training in the various law schools. It was hardly touched in the Law Development Center. So there was a little bit of apprehension as to what the output is when you go for a mediation. But increasingly, we decided to go through a process of sensitization, and mediation started to take root. And one of the interesting things is that at least by about 2013, when we had really settled in with the new rules of the Judicature rules of 2013, The commercial court was disposing of about 25% of its workload using mediation. This was interesting because that meant those were cases that did not have to go to litigation. And it opened an absolute new track where parties themselves could be assisted by the court to come to a resolution of their dispute, and then continue with their businesses. Of course, under mediation, it was largely a win-win situation, as opposed to litigation where there was a winner and a loser. It also spun off literally no appeals. So when it closed, it went out of the court system, unlike uh, litigation, which would continue on further appeal to the Court of Appeal to the Supreme Court. And so right now, what we are seeing is a process where what was experienced at the commercial court is being rolled out to the rest of the Ugandan judiciary. Interestingly, not just only at the high court level, but also in the appellate courts and in the trial courts, whether they be high court or the magistracy. So I think the experience over the last 23 years will suggest that uh, mediation has come of age as a form of dispute resolution. I'll stop there.
Thank you so much, Justice Kiriabiri, and that was really insightful. From 2003 to 2026, the different reforms from just commercial to now more. And maybe Senior Counsel Gimara, you can tell us, and I hope you can switch on your camera so that the participants can see you. From your work as an ADR practitioner, legal experts in multiple jurisdictions, what do you think distinguishes mediation systems that have succeeded? And what is it in the current rules that you think will help us to get Uganda to be in a successful mediation environment?
Thank you so much, Moderator Barbara. And I want to, of course, acknowledge the tremendous contribution of Justice Kiriabwire, as he has highlighted, the journey of where these regulations, these rules traces its origins from the commercial court, as he has articulated. And for me, I look at these rules as an opener, and globally, as you know, moderator mediation is taking its seat as a key dispute resolution mechanism. We have the Singapore Convention of 2019, which is aimed at elevating the practice of mediation to very high levels. But what is important about these rules is that they come at a time when the courts are rebooting mediation. Mediation took a turn when we had the 2013 rules, but those rules made mediation compulsory, but in a major way, there had not been a lot of work done to mediation as a profession. So in a way, this affected its uptake. But in the last couple of years, we have seen a lot of push, including places like the court, even without the rules specifically providing for appellate mediation. Mediation has already, been implemented. So in a practice of mediation has over the years gone ahead of the rules. So what the rules now are trying to do is to catch up. And in an attempt to catch up, we see quite a number of innovations. The key one is the underscoring, and you know how it defines a mediator. It brings in an element of professionalism, also an element of expectation that mediators will be upskilled, will be people who are trained, and this is very important in court-annexed mediations because it begins to move mediation from a show or merely a process to actually an actual tool to help parties resolve the dispute in a win-win. So in terms of defining a mediator as a third party who facilitates the resolution of the dispute, we see that the rules are beginning to build on what actually mediation is. Then we also see that the principles of mediation have now been well articulated. Of course, in 2013, they were there. Whether I talk about party autonomy, we talk about confidentiality, and, impartiality. Those principles are brought up well, but also something that I have seen which is important, to anchor those principles, there is now an expectation that people will follow a code of conduct. A code of conduct is now provided at the end to guide mediators, but also to give parties that utmost confidence of what a mediator should do with the mediation process. So I look at these rules as having taken us a step ahead. Of course, more should have been done, but looking at it in terms of how now the court-annexed mediation is streamlined is something that we need to highlight. Because, for instance, now we have a mechanism for accrediting mediators, and an expectation these mediators will be trained and will be professional mediators. And there is evidence that in the last couple of 1 or 2 years, since Chief Justice Emeritus Owiny-Dollo relaunched mediation, we have seen people being trained. We have seen a lot of disputes being resolved through mediation, including a huge case in Supreme Court that had taken many years, involving the Kingdom of Buganda, was resolved through mediation. Now, what the rules are going to do is to try and build on that train, the train of effective resolution of disputes using mediation. And the other thing that we see the rules do, there's been a debate. Should we make mediation compulsory? Should we make it voluntary? And I think that at the drafting of the rules, there was a thinking that if a case is amenable to mediation, then the court should immediately push it to the mediation track. But we see that the rules that have come up emphasize a lot of an administrative deal, but still go on to note that this mediation is voluntary, which is, of course, tied up with the whole notion of mediation, that the parties are really in charge of the dispute. So but now, what that brings then, Barbara, is that you then have got to have skilled mediators. Because if the process is voluntary, it can only work when the people who are mediators really have the skills to get the parties to win-win. So it's not going to be negotiable for mediators not to be skilled. They need to understand communication. They need to understand negotiation. They need to understand those tools that help advance a mediation towards great closure. And I also say that for the advocates, it is an opportunity, and I see many advocates online, for us to embrace mediation call as something that we should add on our menu. But also, now the rules clarify that even as we help our clients go through mediation, our role is not to be litigious. Our role is at mediation to assume an advisory role. Advisory role meaning that we retain our legal advice, but we let the parties be at the front seat of mediation. It's party-led to the extent that even those parties who are corporates, the rules require that they only send people into mediation with authorization to close the mediation. So we see that the parties have been brought to the front of the mediation table. And ideally, that's how mediation should be, because mediation is about the parties owning the dispute. It's about the parties. You as a mediator, your duty is to manage the process of mediation, but the outcomes must be owned by the parties. And if you're going to own the outcomes, it becomes very, very important that they participate in the process. It becomes very, very important that as a mediator, you create an environment that enables them to have a win-win. So we see that the rules are anchoring clearly the roles of the court, they are anchoring clearly the roles of the parties and as well as the role of players. But also, mediation has to be conducted now within 2 months. You know, that element has been retained from the 2013 regulations. But the other thing also, we see that even when a mediator has been recommended by the court, when you read carefully at the annex of the rules, Schedule 4, you will find that a good mediator or a mediator is now required to as well have the party buy-in, because it's always important that the parties buy in into a mediator before commencing the mediation. So I think that the improvement in that process will see a lot of uptake, because there's a lot of party autonomy in these rules, meaning by the time the parties agree to a mediator, by the time they sit down, then most of those parties, with the confidence they will have lent to the mediator, I remain very optimistic that the level of closure of mediation cases will be very high. So the rules in a major way are bringing in these principles. And as I've said, it is becoming a norm to resolve disputes better. Mediation is becoming fashionable, and this court-annexed mediation rules gives us the opportunity to grow this practice and as well as help our clients have better outcomes as far as dispute resolution is concerned. Thank you.
Thank you, SC. Back to you, Justice Gimara, Justice Kiriabiri, just flowing from Gimara's presentation on the new features of the new rules and sitting as a Court of Appeal judge. I'm wondering if you can tell us what your view, especially on the inclusion or the encapsulation of appellate mediation in the current rules, and specifically how you think that this is going to advance mediation in the appellate level. Over to you, Justice Kiriaburi.
Well, so the 2026 rules, for the first time, even in their definition, refer to appellate mediation. And I think this is in response, if you look at Rule 4, this is in response to a desire that the appellate mediation process is embedded in our rules of procedure. This is largely because for a long time it was felt that when you have a judgment from a trial court, then that is it. You cannot compromise that judgment by consent of parties in a bid to acquire or to promote a win-win situation or dispute resolution, as it may be. So for the first time, Part 5 actually provides a framework for appellate mediation. And for those who were struggling about what the nuts and bolts of it are, they can read Part 5 and then be able to get a structure within which appellate mediation can be undertaken. What we have seen, of course, as you know, in the Court of Appeal, where it was first piloted, that parties are increasingly finding a route out of the courts, even at the appellate level, using this process of appellate mediation. At first, when we were trying to start it, we actually used to choose cases. We used to go through registry, and then as a court, try and find cases or appeals which were amenable, in our view, the view of the court, amenable to some form of reconciliation, some form of compromise, and then invite the parties to come and they attempt it. So it was then at that point led by the court. And of course, this was part of the court backlog strategy. But as we speak today, the court no longer profiles cases. The parties themselves apply to court for an opportunity to be supported to mediate the appeals. And right now, we have a docket of close to about 180 appeals pending hearing. And last year, we were able to close about 300 through appellate mediation. So this is validation of the fact that even where there is a judgment, it is possible to still reach a resolution of a dispute that is on appeal. That allows for a faster, a more efficient, and cost-effective way of dispute resolution. It also has shown us that there is a possibility, even at appeal, to bring in reconciliation between the parties. It is possible to bring in harmony within the parties, because the higher you go using an adversarial system, the more interest you are in positions that you have taken, as opposed to options that are out there. So the only difference is that they would have to be, these rules will have to be read in conjunction with the Court of Appeal rules, especially Rule 94 of the Court of Appeal rules, whereby if a settlement is reached, then the appeal itself will have to be withdrawn under Rule 94. But these rules come at a very good time, because the Court of Appeal rules are currently being reviewed, and this will allow alignment between the Court of Appeal rules and the new appellate mediation rules of 2026. I think what is also interesting is that, and this is not exactly provided in the rules, because the rules provide that mediation can take place at any time before judgment. We now have a unique case. I can't remember all the parties, but it involved Hot Law as the appellant. The participants on the call can check it out on ULI. Actually, were able to settle the appeal even after judgment was rendered on appeal. So let me be clear about this. This is a case where the parties went to appellate mediation. The mediation failed. The file was then referred to a panel of 3, a judgment was rendered, and a notice of appeal to the Supreme Court was filed, but still the parties came back to us and said, even in that situation, they still wanted to talk, and they settled the matter, even after a judgment had been rendered. So this goes back to the basic principle in mediation, that mediation can be conducted at any time, before the coming to court, when in court, before judgment, and even after judgment. And this is also validation of the fact that even after a Court of Appeal judgment, it is possible to continue negotiating a settlement. And that opens a door to appellate mediation at the Supreme Court. And as you have heard, they have already started. But even between the Court of Appeal and Supreme Court, we are seeing people settling. And I think that's why I'm saying that this is a piece of legislation or rules which is the coming of age of mediation. And I think we're going to see it just simply grow. Thank you.
Thank you, Justice Kirabir. And before I leave you, I just want to hear your comments. When you look at Article 126 2E of the Constitution of Uganda, that requires court to encourage reconciliation between the parties, and which has been used severally to direct parties to mediation, and compare that to the language used in the current mediation rules, where will the court find a balance or promote the balance between the voluntariness that has been encouraged under the rules vis-a-vis the direction or the objective that the mandate that has been placed on the courts by the Constitution to encourage reconciliation? How will you find a balance, and how will you encourage the use of mediation, especially where parties may not be willing to go for mediation?
The position that we used to take as a trial judge when I was at the commercial court was that mediation was compulsory to attempt, but not compulsory to settle. This was the view that we used to take, having that provision in mind, and also Order 12, Rule 1 of the Civil Procedure Rules, which asked that the court before trial must inquire into what is agreeable, what is not agreeable, and whether alternative dispute resolution, including mediation, would be suitable to resolve a dispute. Of course, the feeling is that when people come to court, then talking has failed. Sometimes that is true. Sometimes, I like to say, many times that is not true, because we have seen, as I have given you an example, in the hot law, they had been, because that was a labor dispute. People keep talking, they get out of talks, they come back into talks, they get out. But the important point which I want to flag is that even when people get out of talks and then come back into the court system, then go out of the court system, it is important to realize that the settlement was still faster than if the matter had gone all the way to the Supreme Court and a decision made at the Supreme Court level. So it was still able to save time, save money, and get out in an efficient way. Sometimes when you're having these negotiations, people take it as an opportunity to weigh each other. What are their options? Because that's what mediation is about. It's about exercising various options to resolve and use those options on offer through a give and take process to come to a settlement. So the issue of whether it should be compulsory or not, I think we need to be very careful about this argument. I do not believe that there is anything that cannot be subjected to a negotiation. Even at the Court of Appeal and Constitutional Court, we have had people talk and withdraw constitutional petitions for interpretation. And the original feeling was that if a question for interpretation has arisen, then the court must interpret it. But then perhaps during the process of preparing the hearing, one of the parties becomes clearer as to what the interpretation of that article is, and therefore they no longer need the court to make that interpretation. So they withdraw it. And that saves, again, our workload and time. Or if, for example, it is just established that this is not a question of interpretation, but it's an order, it's an Article 50 requirement for enforcement, then people would adjust accordingly. So I think when a judicial officer is starting a trial at any level, it would be incumbent upon them to ask the parties whether they have considered mediating the dispute or applying any other form of dispute resolution before going into the hearing itself. The judicial officer should also take it upon himself, as is provided in the rules, to explain the advantages of mediation. Not that the judicial officer has made a decision on which way the dispute should go, but the advantages that come with mediation. And then leave it to the parties to say yes or no. But even remember, even at that point, even though that the case begins, the parties may still resort to mediation at any point before judgment. The constitutional imperative is the default that courts should encourage reconciliation amongst the parties. That is the default position. I will stop there. Thank you.
Thank you so much, Justice Kiabiri. And maybe SC Gimara, considering the introduction of the new features, and you also mentioned the introduction of accreditation and performance reporting, as well as the complaints mechanisms and the remuneration that have been changed in the 2026 rules. Maybe you can take us through what the changes are and how does this affect the mediation practice going forward? Francis, if you're speaking, you are muted. Francis, if you can speak, we can now.
Can you hear me?
Yes, we can hear you right now. Please proceed.
Thank you. So now, if I may take us through the process, this is court-annexed mediation, meaning that it is going to be mediation conducted under the authority of the courts, and we have laid the framework being the Constitution within promoting reconciliation amongst parties. So it starts with the cases. So typically now, a case is filed, a couple of things. Still, the 2019 Civil Procedure Amendments call for leadership of the court in determining whether a matter should go for mediation. But I agree with Justice Kiriabwire, there is almost no dispute that you cannot talk about. Maybe if there are particular disputes where a question of law is being sought very specifically. But in major ways, when a matter is now filed under the 2019 Civil Procedure Amendment rules, you recall that the rules was calling for leadership of the court in terms of the registrar and eventually the judge to look at the file and determine whether the same is amenable to a mediation or use any other method to quicken its case disposal. And the rules created a framework for active leadership, meaning that unlike before where the court system was like a factory, you file and wait, the judicial officers are required in the beginning to think through ways in which you can resolve the matter much quicker, meaning they read the file and engage the parties. And that was why the parties had been asked under those rules to set down the suit for hearing as soon as they can. But the key thing that we need to take away from in terms of the journey of mediation, we now see that after you file, mediation now begins to become a tool that should be deployed in having the matter raised. The commercial court is now asking that you file the mediation summary together with your pleadings, but also under the rules, you now have that opportunity to look through at the division or the court to see who are the members are. And you can also indicate your preferred mediator in line with the premises of the rules that require that this be voluntary. But either whether you choose a mediator or not, the rules still give the powers to a judicial officer to refer the matter to mediation and to also appoint a mediator. Now, when that mediator is appointed, I still think when you look at the schedule, that mediator is still with you before you sign that agreement, confidentiality and inadmissibility agreement, which is at the tail end of the rules. If you read that carefully, you will find that it talks about you having, for instance, agreed to me, Francis Gimara, being a mediator. Then it says you will not call me to court, you will make this mediation confidential, and all those key principles of mediation. Now, definitely by the time party reads that, the way I like to do it, I like to tell parties that even if I have been recommended to you as a court-annexed mediator, I like to tell the parties that, yes, I have the qualifications, but we also are made list. I would like you to express yourselves. If you are not comfortable with me being a mediator, I am very happy to recommend another mediator to you. But if you are comfortable, I would also like you to indicate your level of that, and we proceed. So I like to, every mediator has a different style, but I see that the rules, even when the judicial officers can refer it to a mediator, I like to submit that it is very important that at the mediation table, you first get the parties buy-in at the commencement. And I like to do that. The judges, many times who are mediators, perhaps not, because we know them, they've been judging matters. But for us who are mediators, who are handling court-annexed mediations, it becomes, because we are doing it on behalf of the other, it becomes very, very important for you to have total party buy-in. So we see that the rules give us that opportunity. I also now note that after now the matter has come to a mediator, you are required to mediate with certain standards. There is an expectation of performance, and the mediation also must be conducted in court premises, but also you need to consult the parties. It is possible you can have it out of the court, but also I see a new feature: the mediation should be conducted in a language that the parties are comfortable with. So English is provided, but also now it opens this up to Conduct it in Luganda, conduct it in Soga if the parties are. But so after all, the record of mediation is not required. What is required are the outcomes. So we see that the reporting format is very, very clear. So when you start the mediation, there are some expectations as well. For instance, the issue of conflict of interest. You need to declare conflict of interest to the parties. And if you don't, you potentially will be in violation of the code of conduct. And now there's also a mechanism to discipline mediators, which was not in the rules before. The mediators can go through a disciplinary mechanism, which can actually have your name revoked from the list of accredited mediators. So we see that there is a call for a lot of professionalism. And then the other future now, when you start the mediations, you have 2 months to finish the mediation, but also the performance of the mediator is tracked, quarterly, monthly, and quarterly. So I see that as a good thing because in math they say what is not measured is not achieved. So you need to track performance and ensure that the mediators as well help in resolution of these matters. Then we also see that the mediation must now take place within 60 days. That was in the 2013 rules. But here we have a rider, it can be extended, once for a couple of days. And then, of course, when you are done with the mediation and there is a successful mediation, you send it to the judicial officer to record that. And we also see that after that has been recorded, it now takes the process of being enforced like any other court order. But also key is that there are now some grounds where the agreement, even when you have signed it and endorsed by court, we see that there is some clarity that on grounds of fraud, on grounds of you can set aside a mediated settlement if there are those specific grounds that are violated, provided for in the rules. For instance, if it was obtained by fraud, it was obtained through means that are not fair to the parties, or if there was, confidentiality, or if you, the mediator, pushed one of the parties to settle, and there's evidence that that is not what they wanted to do, but they settled because probably out of respect of you as a judge mediator, that can be set aside. So we see grounds for setting aside the mediation are also now very clear. But I also see the other good feature of the rules is that you can now be able as a mediator to decide whether you need that mediation summary. In the past, you file everything, but it is, in my view, I've read the rules carefully. It doesn't say that in each matter you should file the mediation summary, but it says if the mediator deems it necessary, you can even file after. I think the issue of filing mediation summaries before and then going with it to ensure it is there has been one of the features of 2013 rules. Now I see that the language is more permissive. You sort of file if the mediator really needs them. In many cases, because a mediator is a manager of the process, many times they want to go into the mediation, some of them, and then begin to engage the parties while there without even having gone through reading of the mediation files. But in some instances where you are doing evaluative mediation in particular courts like commercial, where the level of expertise needed is very high for you as a mediator, then the rules, definitely you have to make use of the rules by asking for the parties to file a summary of the mediation. But also, interestingly, Barbara, as a mediator, you are not supposed to mediate every matter. If the matter is beyond your skills, the rules say that you are at liberty to decline, and it would be important that for you, not every matter you should jump into it. And this is very important because some matters are very, very technical. I mean, in the commercial court, if it's a technical banking matter and it comes to you, you are free to say, no, 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 I am not able to do this. And if you don't and you continue, it may be a violation of the code of conduct. So a number of motives. But in summary, yes, the path is now very clearer. And also, Justice Kirawira has hinted at this. You also can, even if a mediation fails, what the Court-Annexed mediation rules say now, it opens up mediation at any time to be picked through the lifetime of a case. So you can as well fail the mediation, then you start the trial before a judge, and then the judge says, but this matter, guys, try mediation again. That in itself is now facilitated by the new rules. So the whole rules is to mediation across the entire chain of the judicial system, from the magistrates court, of the civil judicial system, from the magistrates court, high court, court of appeal to Supreme Court, and at any time now. You know, unlike those days, mediation was only in the beginning. 60 days failed, the matter now goes for trial and only trial. But the rules seem to say, you know, at any time of the trial process, you know, you can start mediation. You may fail to talk now because you are probably all angry as parties, but the backlog has a way of you know, humbling you. The backlog can humble you after about 1-2 years, and then you say, but I've been in court, the matter is not moving. For such scenarios, the rules are now permissive that you can start the mediation at any time. Thank you, thank you, thank you.
Thank you, SC. And you raised a point, and I want to be a little controversial with it. And Justice Kiriaburi, please excuse me, and you can dismiss this as the Kenyanness that I have. So the new rules introduce performance reporting as a mediator. Will this be the same level of performance reporting and quality monitoring that will be applied to judicial officers who are also accredited as mediators? What is your view on that? And that is my second last question to you before we close the session.
Barbara, I thought the time you have been in Uganda, we had converted you into a Ugandan and diluted that Kenyanness of yours. But
You'll excuse me. It seems it keeps coming up sometimes.
But one of the things that has been a problem in the other rules is how do you manage the whole process? And if you remember, under the 2013 rules, the management of the mediation under the Commercial Court Division mediation rules and the mediation rules of 2013, there was what was called a monitoring and evaluation committee. And the purpose was not only to monitor performance of the mediations themselves, but also of the mediators. Now, under the 2026 rules, before I get to the 2026 rules, I must point out that the Monitoring and Evaluation Committee hardly sat. And therefore, there was a problem because it was an ad hoc committee. It rarely sat. I don't recall more than 2 or 3 times when it actually sat, and therefore that might have affected the performance of mediation. But under the 2026 monitoring and evaluation has been moved to the Case Management Committee under the AJA, the Administration of Judiciary Act, which is a very active committee, and I think will provide better oversight. everybody is, whether a judicial officer or not, is also accredited. So the Honorable, the Chief Justice has also accredited judicial officers to be mediators, and their performance too will be subjected to evaluation. So yes, the answer to you is yes. I'll just speak for myself. I have an accreditation letter from the Honorable the Chief Justice, and it is very clear. Renewal is subject to good performance. So we must make a distinction between a judicial officer sitting in his judicial capacity and a judicial officer sitting in the capacity of a court-annexed or court-connected mediator. As has been made clear, everybody who is going to go on the roster will have to have done some minimum training. That will ensure quality control getting in. Now, quality control while you're in is also going to be monitored. And it is possible, therefore, that when you do not perform, then you will lose your accreditation to this process under the 2026 rules. It is important to understand that performance, in my view, does not mean that every mediation that comes to you is successful. But it is important that when a file is assigned to you, that you actually progress it and that you actually manage it according to the rules to ensure that the process that has been promulgated is followed up. You will also notice in these rules, compared to the 2013, that they are a lot more, the paperwork is more elaborate. There's enhanced paperwork in this process, which is a good indicator for measuring performance, both of the parties and the mediator. So there is reporting, there are notices to be sent out. I think there must be something like 10 forms in these new rules compared to the 2 or 3 forms that were in the 2013. So the file, even though as Honorable, as Senior Counsel Gimara has said, there is no taking of record, but 2026 actually provides for a paper trail of the mediation, which can be used as an evaluation tool. So what the parties and the mediators need to take note of those particular forms in Schedule 1 to the rules, and ensure that those that have to be acted upon are acted upon and in a timely manner, so that when it comes to ensuring M&E, that these are the building blocks through which mediation can be evaluated. Yes, so it is true that the judicial officers, we're not going to have 2 track standards. There is one standard. And let me also add one more point, which is with regard to schedule number 2. These rules, for the first time, upgrade what was called guidelines in the 2023 rules to code of conduct. for mediators. So in 2013, I think the reference to guidelines for mediators seemed to be loose in terms of enforcement. And now there is a code of conduct. So even for a judicial officer, in fact, the onus is heavier on a judicial officer, because if you're a court accredited mediator, then you have to make sure that you still stick within the code of conduct for judicial officers and then the code of conduct for court accredited mediators. So I just wanted to add that footnote as well. Thank you.
Thank you so much, Justice Kiaburi. Gimara Francis, maybe before we get to your closing remarks, I'm curious about the training element and the standards of training that should then be imposed either to the training institutes or to the accreditation process. What's your take on that?
My take on that is it begins on how a mediator is defined. And when you look at the definition, it says a mediator means an independent and neutral third party who has the expertise to assist the parties to reach a settlement. And I will underline the word has the expertise. Now, in having the expertise, you obviously, when you are applying to be a court-accredited mediator, and I hope that there are people who are on this call who will want to do that, you definitely then follow Schedule 1, which is a form for application for registration and accreditation to the Chief Justice through the Chief Registrar. And you say, I have attached a copy of my academic and professional certificates. Now, obviously, in terms of the professional certificates, I would like to say that the recommended standard world over is you as a mediator must at least have undertaken a mediation training of not less than 40 hours. And I would think that if a person has done that from an institution that is credible, an institution that is known, and they have done the 40-hour, then you can attach that to your CV, and then you can apply to be accredited. So there's a process to that. And of course, at LP Dispute Settlement Hub, we set up to do some of these trainings. And we will be calling on, we'll be undertaking a training in the next couple of weeks for those who would like to be a court accredited mediator. And if you're interested, you can drop in your email on the chat group. We will contact you or your number.
Thank you, SC. Justice Kiobire, your final comment before we open up to the participants for their questions. In your view, what would successful implementation of the court-annexed mediation rules look like for Uganda's judiciary 5 years from now, especially given your expertise in leading the small claims court interventions in the judiciary of Uganda?
I think we are in that point in time when we have to have a conceptual change in case management, because for a very long time, the courts were designed to be decision makers, arbiters. But increasingly, the future lies with dispute resolution, and the two are not necessarily synonymous. Being an arbiter is simply a subset within dispute resolution. And so what we're looking into going into the future is a a court system that is now referred to from the US parlance as a multi-door courthouse. Because normally when people would come to court, they expected to go through one single door, which was litigation, and therefore adjudication, which was adversarial, ending up in a decision. But I am now seeing a court going into the next 5 years with multiple doors where people can knock on and try to have their disputes resolved. This is really to create greater efficiency in dispute resolution. And so there will still be those who knock on a door for litigation. Those will not go. But I think the line will be shorter moving forward, because some will move out of that line, some will move out of that line and move into the line of mediation. Others will move out of that line and go into the line of conciliation or arbitration or small claims or plea bargain. You can see the options are clearly increasing. And this, I think, will define the courts of the future. So in terms of the judicial officer that we are going to see going forward, we are going to see a multi-skilled judicial officer who is not only able to adjudicate a case, but is also able to lead parties into settlement of that same particular case. That is a new skill set. It's a new mindset that has to be onboarded going forward. The same is true for the advisors or the advocates. Increasingly, the gladiator of the past, who was largely involved in adversarial litigation, the role will become smaller and smaller, and the negotiator will become bigger and bigger. That's a new skill that is going to evolve, where the advocate of the future must also be a skilled negotiator. He must be able to help the parties that they are advising to negotiate settlements that will allow their parties to really get out of conflict, get out of disputes, and move forward with their lives. Already, this is taking place in the countries where we inherited our law practice from. So in countries, for example, like Singapore, it is already documented that 80% of their civil litigation is settled, and only 20% of the cases go to trial. In Uganda, it is the reverse. In fact, it is more than 20%, far more than 20% that go into litigation. The question, therefore, is, if we are going to be like Singapore, can we continue to be the way we are, where we have more cases going into litigation than into alternative dispute resolution? The same is true, by the way, for criminal practice. In the United States, about 98% of all crimes that are booked
in the American criminal justice system are resolved without going to court. And even with all those many cases that you hear of in the American court system, it's about 2 or 3% of arrests that are done in that country. In Uganda, it is flipped. So the international trends are clear. The international trends are litigation. Litigation is going to be an avenue of last resort in dispute resolution. And these, what we call alternatives, are going to be the way to go. I agree with Chief Justice Emeritus Owiny-Dolo that when we really look at even the system that we have, it just came to us under the 1902 order in council. It has only been with us for probably, should I say, about 124 years. And what were we doing before? The traditional justice systems that we had within our own communities were more amenable to what we now call mediation, and the population understands it better. We have a lot of words for it in our local languages. And so I think going forward, we're going to see a systemic change in the way disputes are handled. Thank you.
Thank you very much, Ajahn, for your time to just stay with us and give us your thoughts on the new rules and also your guidance on how to make sure we adhere to the code of conduct and to also remain relevant in the international arena. SC Gimara, your final thoughts, and maybe as a practitioner, because this question has been asked in the chat, how does one retain their accreditation status? And specifically, maybe you can also help us to understand for the training institutions, especially, how will they partner with the judiciary to either be included in a register of trainers or accredited trainers? Where do you think this can be anchored? Over to you. And just before Gimara gives us his response, there is a poll that has been published. Please click on get the QR code. We are happy to see you, Justice Kiriabwire. Finally, you got your camera on. There is a QR code. Click on the QR code once you get to the poll. Scan it and answer the question on whether you have any recommendations on how the rules can be improved to secure their successful implementation. Francis, over to you for your final thoughts and your advice on how judiciary can partner with other training institutions, as well as how one can retain an active accreditation standards. Colleagues, Eddie, maybe you can reach out to Gimara. I think he has dropped off the call, and because I do not see him. But in the meantime, perhaps Justice Kiriabwire, if you can be willing to answer some of the questions that have been raised, or if anyone has a question, kindly raise your hand and we will unmute you. Justice Kiriabwire, maybe if you have a thought on how one can retain their accreditation standards or improve or undertake continuous professional development as a mediator.
I think like every profession, if you're going to be a professional mediator, you have to continue with, I would like to call it a form of continuous mediation training, CMT. And you'll find very many options for doing this, the training provided within the judiciary at JTI, training within ALP Dispute Settlement Hub, being part of the Chartered Institute of Arbitrators. They have training for mediators. There's a lot of literature which is out there, which is available on mediation techniques or mediating in specialized areas like environment, like energy, construction. You can move into super specialization that is also available. So I think it is not sufficient to rest your laurels on the 40 hours that would be the initial training. I think you need to continuously upgrade yourself in the techniques that are taking place. Even today, we're now seeing what I'd like to call hybrids. There is MedAb, for example, where you can move from mediation and transit into arbitration. That is also a new hybrid that is coming into the dispute resolution space. So even mediation itself is going to evolve. You need to evolve with it. And if you're going to be a very good mediator, it's important to know that the more you do, the better you become. And also you need to know that the more you study, the more informed you shall be. So I think that's the way forward.
Thank you so much, Judge. We are almost out of our time, and I have noted that the comments that have been included in the chat box are mainly interests in securing a training. I think we have all understood Justice Kiriabwira when he says that it is important to continue improving your capacity as a mediator. And for those that are accredited, I think the rules are quite clear. Reach out to the registrar in charge of mediation to get a confirmation of your status. With that said, I would like to thank all of us for participating in this particular discussion, and specifically to just on behalf of the organizers to express my sincere appreciation to all of you who have participated in this dialogue, and especially express our gratitude to Justice Kiriabwira for your invaluable judicial insight and leadership, and to Mr. Gimara, Senior Counsel, for sharing his deep professional experience and practical guidance on mediation under the new rules. And we hope that with your contributions, we can continue enriching the dialogue. It is not the end. We will have other discussions, especially on the kind of responses we get from the poll, so that we can strengthen our collective understanding of mediation as a cornerstone of people-centered justice and sustainable development. I thank you all, and I hope that we can continue having this discussion to reaffirm the central role of mediation in enhancing access to justice, strengthening the public trust in justice systems, and supporting economic and social stability. I look forward to all of you collaborating together as we work together to implement the 2026 rules effectively and to further embed mediation as a professional, ethical, and accessible dispute resolution mechanism within the Uganda justice system. Thank you very much, and do have a beautiful evening. Thank you. I don't know whether the organizers have something final to say from the comments that have been included in the chat box. Maybe a final word? Eddie, over to you.
Thank you, Barbara, for that. We've taken note of all the emails that have been shared. So whoever's shared an email, we will write to you about our upcoming training, but you can also check out our socials. We're on Twitter, we're on LinkedIn, and we always have upcoming opportunities and trainings and also webinars that can be helpful for you. Other than that, I don't have much to say. We'll have that we'll share recording for those that need recordings that have shared their emails and requested. So it is also available on request for you. Thank you very much and have a great evening.
Bye-bye. Thank you.